First of all, I'd just like to take this opportunity to express my gratitude to our esteemed speakers and to all of you who have taken the time to join us. Your participation is what makes this webinar a valuable platform for dialogue and development. The Maldives, known for its stunning natural beauty and vibrant tourism sector, holds a unique position in our region. As a hub for international tourism and with a growing real estate market, it faces distinctive challenges and opportunities in resolving commercial disputes. The need for a tailored and effective ADR framework has never been more evident. A robust ADR system is not just a legal necessity, but a crucial driver of investor confidence, economic growth, and regional stability. As we begin our discussions, I encourage you to engage fully with the presentations and discussions, bringing your own experiences and perspectives to the table. It is through this rich exchange of ideas that we can identify the best path forward. Here's to a fruitful and productive session. Now that we have formally started with this webinar, I'd now like to introduce our current Director General of SARC Arbitration Council, Mr. Choining Doji. Just by way of introduction, Mr. Doji is a seasoned legal practitioner and has previously served as a member of the National Council in the Kingdom of Bhutan. Additionally, Mr. Doji has also served in the Royal Civil Service Commission of Bhutan, as well as in the Anti-Corruption Commission of Bhutan. Mr. Doji is our 5th Director General, and it has been due to his guidance and support that SARCO has been able to continue its important work of promoting the use of ADR in the SARC region. Furthermore, it's because of his effort that we have been able to organize important events such as this webinar, which brings together people from different spheres of the world, thereby promoting regional cooperation and synergy. Please allow me to welcome Mr. Doji to give the welcome remarks.
This one. Okay. Thank you, Shakib. Good evening to all. I think we have people joining from different parts of the, places. And first of all, let me welcome all of you to this important webinar, especially Khurram Shahzad Mughal, our governing board member, then Madam Sadia Awan, Director SAC, Ministry of Foreign Affairs, Government of Pakistan, Mrs. Shafia Riza, Managing Partner, RCO Lawyers, Dr. Daksha Sharma, Assistant Professor, SAU, Barrister Vishal Shamsi, Co-founder, Harmony Resolution Center, and all the other participants. I would like to welcome, especially to our 4 speakers. I am very grateful they have agreed to share their knowledge and expertise and experiences with us. I am sure all the participants will benefit out of their presentations. SAC Arbitration Council organizes a number of activities in various member states in a year. So we have completed training session in Bhutan, Bangladesh, and webinars in Pakistan, Nepal, and Sri Lanka. And of course, one of the physical activities or program we have planned for in India could not be carried out. We are carrying forward this to the next year in 2025. So, as I mentioned earlier, all these activities are aimed at promoting the growth of arbitral institutions in the region. This is one of the mandates given to us by our establishment agreement. And if you look at the agenda items today, or the subject matter to be covered by the webinar, I find a very interesting topic. Is as my colleague mentioned, is specifically tailored to the needs of the Maldives there. And I expected this webinar to be very interactive and open session. I encourage all of you to engage fully with the speakers, ask questions, share your thoughts, and interact with the fellow participants. I guess the usefulness or the otherwise of the webinar is your participations, active participations in the webinar, and I hope you will make it very open, interactive, and engage discussion. In closing, I wish you all a very engaging and enriching webinar. Thank you to all of you.
Thank you, sir. So, ladies and gentlemen, our first thematic session is based on the arbitration landscape of Maldives. Now, before I invite the first speaker, let me just take a few moments to introduce him properly. Mr. Ahmed Shujao Sharif is a practicing attorney and the managing partner of the Island firm. He completed his LLM in commercial law at the University of West England and has worked at esteemed law firms in the Maldives such as S&A LLP and CLA Partners. He has also served as in-house counsel for MTCC and is currently a lawyer for Maldivian. Exceptionally enthusiastic to contribute his knowledge and expertise, Mr. Shujao also participated in the recent elections as a Complaints Bureau member for the Elections Commission. Mr. Shujao is dedicated to continue efforts to support and uplift the legal profession. Mr. Shujao, thank you so much for joining us today. And I would now like to invite you to provide us an overview of how the ADR framework in Maldives is evolving. Mr. Shujao, can you hear me?
It's a bit, right?
Yeah. Yes, Mr. Shujao, can you? Sorry, ladies and gentlemen, this always happens. We'll just wait for Mr. Shujao to turn his mic on so that we can continue.
Hello. I believe you can hear me now.
Yeah, yes, Mr. Shah, thank you.
Yes. Oh, okay. Thank you. Apologies. I think maybe the connection issue, but let me on my camera as well. So I think you will be able to see my visual right now. Okay. Hello all. Thank you, and just want to send you greetings from Maldives Moot Court Society. I am currently the advocacy director of Maldives Moot Court Society. And as mentioned, I am the managing partner of the Island Firm LLP, and also I currently am the legal manager of Allied, the lead insurer in Maldives as well. Regarding my topic, I was thinking the evolving alternative dispute resolution framework in Maldives. It's a very general topic, but to give you an understanding of how the framework is right now, we need to understand the history and also the existing practices. And I believe my colleague, Ms. Shafia Riza, will explain in detail regarding the specific component tourism-related dispute resolution mechanism, which are existing right now. But to move forward, I would like you to have an understanding that Maldives the litigation in the court proceedings, we used to have dispute resolution mechanism. That is not the alternative dispute resolution mechanism we see outside court, but that was very effective until the 2021 Civil Procedure Code in Maldives. So what happened was before Civil Procedure Code, the court proceedings led to conclusions in a much swifter manner in dispute resolution framework. So the court, under the regulation, they allowed prior to litigation a dispute resolution mechanism where the judge will be there mediating the two parties, and the two parties come to a conclusion, and they do not go to litigation, which is very helpful in the legal system in Maldives. With regard to the history, what I went through and researched, and I noticed that we used to have because Maldives is a country, we used to have island chiefs. We call them Khatib in our language. The island chiefs, they become a mediator resolving conflicts in the islands. So the community, when they have an issue, they meet with the island chief, and the island chief will have two parties come to him and try to resolve their disputes verbally. So there was no formal practice. This was an informal practice, and this was a traditional practice based on the Islamic law and local customs in Maldives. So there were no written basis, human tree, any specific method before arbitration act of Maldives. So this was the informal system which we used to have. And when we talk about the alternative dispute resolution, the real mechanism came to existence under the Arbitration Act 2013 in Maldives. So this act laid out the groundwork for the Maldives International Arbitration Center, which is an institution to provide an alternative dispute resolution mechanism in Maldives officially. So this was the MIAC, we call it, the body which provided a modern approach to dispute resolution and also focused on practicing internationally recognized standards as well. So we do have MIAC rules as well, which provides the solution which we want from the alternative dispute resolution. So we do not want to approach to the courts because firstly, the cost due to the extreme high cost of the litigation process, and also due to the significant delay which we see in the normal court proceedings. Litigations take a lot of time. Most takes in Maldives as well. It takes around 1 to 5 years if it count the appeal process as well. So this is the normal timeline, and the alternative dispute resolution mechanism provide us a swifter, a faster method which the parties can resolve their disputes. So the challenges which we faced due to the Civil Procedure Code, this led to more people, more businesses, more individuals choosing the method of alternative dispute resolution. So there are some cases in the MIAC right now as well, but because of the proceedings that are held in mediation or arbitration in MIAC, they do not allow to disclose this information. So this arbitration method, or the alternative dispute resolution method from the MIAC, provide the parties a way to have their disputes confidential as well. Court litigation system, we have publications of cases as well, so which means their disputes are often found in the media. So that might not be the ideal situation for every party. And also the arbitration system allows the parties to choose their arbitrators compared to the litigation process, which do not allow, as we cannot choose a judge. Then the judge is chosen by the mostly in the states. So what happened is this alternative dispute resolution mechanism provides us this solution as well. Moving forward, what I would like to discuss is regarding the current state of the building on the past and the recent practice which we saw in the court litigation as well, the court dispute resolution mechanism as well. We saw by MIAC, we saw a way to move to the next phase in our ADR evolution. So the center's focus on arbitration not only provides a more structured alternative, but also ensures that outcomes are binding, enforceable as well. So any arbitration conclusion or decision can be enforceable in court as well. So this also helped to come to a resolution in the manner where the parties would be more interested to choose this. So looking ahead, the evolving ADR framework in Maldives is not merely a response to judicial inefficiencies, I would say, but it is a proactive strategy to foster trust, and also it is crucial to invest in capacity building, awareness program, and legislative support to ensure sustainability and growth of ADR mechanism in the Maldives. So, in conclusion, the evolution of ADR framework in the Maldives highlights our commitment to adapting the needs of modern justice system as well. From the historical roots of mediation to the establishment of MIAC, the journey represents progress, innovation, and dedication to justice. Thank you all for listening.
Thank you, Mr. Shujao. Thank you for the very brief and succinct overview of the ADR framework of Maldives. And it's very interesting to note that how it started from the chiefs of each island, and now it's taken the shape of an institutional framework. I'm aware of the fact that MIAC, I think, is the only body which deals with, maybe at the national level, any dispute resolutions, alternate dispute resolutions. But I believe that I'm sure there will be more ad hoc arbitrations and mediations as well now up and coming, because Maldives is also a growing economy, and as we also know that there's a lot of influx of international investment as well, especially with the new hotels and the resorts. So I believe that will be the way forward, and hopefully we'll see further developments in that regard. So moving to our second thematic session, this topic relates to ADR in the tourism and the real estate sector, something more targeted towards these two industries, which are very prevalent in Maldives. For this topic, we have with us Barrister Vishal Shamsi, who's the co-founder of Harmony Resolution Center, which is based in Pakistan. So Harmony Resolution Center is a joint project of two NGOs, DPS in Rabat, that provides dispute resolution services free of charge for various family, inheritance, civil, and commercial matters. Barrister Vishal Shamsi also practices as an independent legal consultant and represents clients in complex commercial disputes before various courts and tribunals across Pakistan. Additionally, she presides on arbitral matters at the Pakistan Stock Exchange. Her broad-ranging engagements comprise of advisory and consultancy, as well as corporate and commercial work. Barrister Shamsi has authored various articles and has contributed chapters in various books, including More Justice, More Power, When Peacemakers Are Advocates, the ACR Practitioners Guide series, which is published by Roman and Litfield. So, Barrister Shamsi, if I could have you on the screen. Thank you for joining.
Thank you. Thank you, Sakab. Can you see me?
Yes. Thank you. Thank you for joining us, Vishal. So, Vishal, given your extensive experience in this sector, what and how important of a role do you think ADR plays in commercial sectors such as real estate and tourism?
Okay. First of all, thank you so much for having me. Thank you, SARC Arbitration Council, and all those that have joined this webinar. It's a very interesting topic. So first, when I was approached, it's kind of also interesting because I advise certain companies that are in the tourism and real estate sector. So it particularly caught my mind. Obviously, it's not the same as Maldives. I believe Maldives has a huge range of hospitality market. I was just doing a little bit of research before joining this, and I realized that Maldives has 30% of GDP is based on tourism sector. And if you compare that to Pakistan, we only have 6% of GDP. But especially post-COVID, I feel that local tourism in Pakistan has shot up. And this is where ADR plays a huge role. I think from my personal experience advising my clients that are in the hospitality sector, one bad review can change a tourism company's or a hotel owner's future, right? So I think in that sense, I have personally witnessed that a lot more times, even when the terms and conditions of various contracts are very rock solid, whenever there's a complaint, whenever there's someone, a customer that is not happy with any of the hospitality services, the companies that do provide these services immediately tend to settle. And this is where mediation or arbitration can play a huge role because you need a quicker way to resolve. And I think mediation, one of the few characteristics that mediation and arbitration has is that it's immediate dispute resolution. If not immediate, then faster dispute resolution, and it's cost effective. And as also mentioned previously, that it's also cheap. So it's cost effective, it's cheap, it's efficient. You can do it in a short period of time. You can resolve various disputes. I think I also caught up on what Saqib did about the previous speaker who mentioned that in Maldives there is a concept of island chiefs resolving, and I think Pakistan has something very similar too, which is applicable in the hospitality sector. So just to give a background, Pakistan is huge country with 240 million people living, and most of our tourism is up north. Not all of it, but most of it. And north or northern landscape is mountainous regions. It's beautiful, but it also has those tribal elements to it. So whenever there are various disputes, not just tourism, but also considering I'm supposed to talk about real estate also. So in real estate sector up north also, many disputes go to these tribal leaders rather than courts. So it's in that way it's very similar to Maldives, and I feel like that is something when we talk about mediation, streamlining all of these other informal methods and giving them the awareness or introducing mediation or arbitration as a formalized concept would play a huge role in this sector because again, arbitration or mediation by someone who is not professional, someone who may not have the right legal background, those awards or those agreements might not be enforceable also. So that's also something that I wanted to talk about. The kind of disputes that we in Pakistan have in the real estate sector are mostly property ownership, title disputes. We also saw various disputes post-COVID about construction contracts, force majeure clauses. So I think we saw a large, we do see in our professional experience a large variety of various disputes, various different kinds of disputes within the real estate sector, and litigation in Pakistan takes years. Like I said, it's a huge population. We do have a network of courts. Parties can go for litigation, but then again, it's not the same. It takes years for disputes to resolve, considering that there are a lot of frivolous litigation also, especially in the real estate sector. A party can go court to court, take a stay, and then the project or the construction is halted for a large period of time. Obviously, stakeholders lose interest also. So that is again another place where mediation or arbitration can play a huge role in the real estate sector. I'm assuming it's similar for Maldives also, but I'm speaking from a very strictly my experience in Pakistan. I think I've covered the tourism sector. If there's anything that Saqib would want me to add, Saqib, then I would be very happy to add.
Thank you, Vishal. I think we can come to maybe the question and answer part maybe at the very end of the session. But thank you
Sure.
for the overall brief about how mediation especially plays a very crucial role in the hospitality sector. And as you already mentioned, in Pakistan, it's also a growing field, maybe not as much as in Maldives or in some other countries in South Asia, but we do have a lot of real estate at least, especially with some new schemes opening every other day. And I'm very aware that this is like you mentioned, litigation is too slow for all of us. And for us to be able to resolve disputes efficiently, ADR in the form of either arbitration, mediation, or any mixture of both is the way to go. If you don't have anything else to add, Vishal, then we can maybe move on to the next speaker.
Sure. Thank you.
Thank you. Thank you for joining us. Okay, thank you, Vishal. So, ladies and gentlemen, so far we have learned about the role ADR. We have learned about the ADR legal landscape of Maldives and how different mechanisms play an important role in the relevant industry sectors. But now the important question arises as to how do we even implement these mechanisms effectively. To elaborate on this, we have with us our third speaker, Ms. Shafia Riza, who is the managing partner at RCO Lawyers. Ms. Shafia specializes in corporate and financial services law, and through past work experience is well versed in legislative drafting. Ms. Shafia became a registered lawyer in the Maldives in 2011. She is a registered member at the Chartered Institute of Arbitrators and a qualified mediator at the International Mediation Institute. She is also a member of the Asian Institute of Alternative Dispute Resolution. Since co-founding RCO Lawyers, Ms. Shafia focuses on foreign investments, acquisitions, commercial legal advisory, and mediation. Prior to that, Ms. Shafia served as an in-house legal consultant at the Ministry of Finance and Treasury, and later as Deputy Counsel General at the Attorney General's Office, where she worked in matters relating to arbitration, human rights, international affairs, and legislative drafting. From 2015 to 2017, she served as a member of the Board of Directors of Waste Management Corporation Limited, and from 2019 till present, Ms. Shafia serves as a non-executive director at Centurion PLC. Madam, we are honored to have you with us in our midst today, and I'm sure it will be an enlightening experience for all of us to hear your invaluable insights.
Thank you. Good afternoon. I first want to thank SARCO Arbitration Council for inviting me and giving this opportunity for us to have a chat about implementing effective ADR mechanisms from a Maldives perspective. For the benefit of the participants, I have just bulleted a few important points that I'd be touching on in my dialogue today. And I would like to share my screen if that's okay. Okay. Are you able to see the screen?
Yes, yes, madam, we can.
Oh, okay. Trying to, something happened just now. Wait, I'll try again. Okay. Right. So I would like to, when we're talking about implementing effective ADR mechanisms, I wanted to focus our conversation on two major points. Number one is about drafting robust ADR clauses in the context of the Maldives, and speak a little bit about how to strengthen existing local ADR mechanisms. So to begin with, okay. Drafting robust ADR clauses in the Maldives, the parties have the freedom to contractually adopt or opt for ADR mechanisms to resolve their disputes. And while we have a very archaic contract law, that contract law recognizes ADR mechanisms, ADR clauses, and also recognizes these clauses being subject to a foreign law. So that paved the way for contracts that are entered in the Maldives to have ADR clauses even before we had the Arbitration Act come into place. And as mentioned by my colleague who spoke a bit earlier, in 2013, we had the Arbitration Act come into force, and arbitration clauses that are governed under Maldives law are obviously governed and recognized under the Maldives Arbitration Act. And in 2019, Maldives also became a party to the Singapore Convention, which is the mediation convention. But however, we have to note that there are no primary laws or legislations equally governing or regulating mediation, international mediation, or recognizing settlement agreements which have been mediated as envisaged under the Singapore Convention. But however, having said that, I would like to note that in a limited context, the laws do recognize form of a mediation. As my colleague mentioned, the new Civil Procedure Code speaks about resolving disputes through an ADR mechanism. I think the reference largely points to a mediated settlement. So parties can opt for both in-house or, out of court or in-court settlement. The in-court settlement mediation procedure under the Civil Procedure Code, the mechanisms are not there yet, as far as I am aware. So I'm not aware that there is a formal mechanism set in place as envisaged by the Civil Procedure Code. Mediation has been ongoing in the family law context for some time now, I would say. I think over 10 years now. Under the family regulations, the family court practices somewhat a mediation, informal mediation to various family matters. Why are ADR clauses important in the sense why must they be drafted properly and effectively? Number one is if parties have agreed to resolve a dispute through an ADR mechanism, the courts would give effect to it. The courts would, the tendency of the Maldivian courts have been not to exercise their jurisdiction over these matters. So, for example, we've seen in various cases where parties have agreed in the contract to opt for an ADR mechanism. The courts have time and again said that they would not continue the proceedings. They would refer the matter to the agreed ADR mechanism. The cases I've cited, for example, Lucky Hill Maldives is a government contract that was awarded to a private party, and the tender board was supposed to is the adjudicator under the agreement, and the parties first entered the civil court before proceeding with the contract envisaged ADR mechanism, and the court said, no, we do not have jurisdiction over it. You have to go back and sort out the dispute in the way you have agreed. A similar approach was taken by the High Court in this insurance case, which I mentioned here, Seaman's Group versus Solarel Insurance, where parties have agreed to resolve disputes by arbitration. However, interestingly, there was one case which went all the way up to the top court, Supreme Court. It's one of the first cases that had been decided in reference to the Arbitration Act. So the case was about concerned two parties. I think you might know the telecoms provider Ooredoo versus Focus Infocom, private company that also provided internet services in the Maldives. So what happened was when in the agreement the parties made, they agreed to resolve disputes by arbitration in the Maldives. At that time, the arbitration center was not set up, and even when they filed the case, arbitration center was not set up while the law was there. So when the cases finished through the civil court and the High Court, the arbitration center was still not set up. So what the Supreme Court said that the court was right to exercise their jurisdiction to oversee these cases, even though the parties had agreed to resolve the disputes through arbitration, merely for the fact that the arbitration center was not set up. So the clause, the ADR clause the parties had agreed on was impossible to be performed by the parties. So that's an interesting stance. So I don't think in the Maldives we will face this issue again because MIAC is set up and running. Coming back to the theme, today's theme about tourism and real estate sector. In the tourism sector, you would see there are multiple levels ADR. ADR is the preferred form of resolving disputes. For example, when a head lessee enters into a management contract with a management company, usually you would find ADR clauses. You would also see ADR clauses in sale transaction agreements as well. For example, when you sell a resort, when you sell a head lease, or when you acquire, when you do an equity acquisition of a resort company as well, you would find parties prefer ADR mechanisms and would often have detailed ADR clauses. In real estate sector as well, we see, for example, Hulu Male, the Greater Male area, has a lot of real estate sector work that's being done, also development works. So you would see with the contractors, the agreements, whilst there would be a mix of FIDIC and a little bit of, tailored into the local context. Usually these agreements would have the FIDIC adopted DAB mechanism, or would have an ADR mechanism where the parties would prefer either to go to arbitration or would have a multi-tier ADR mechanism, for example, where you would first go through internal dialogue, and if it fails, then to go to arbitration. So that is the trend currently. And we see somewhat more often now that cases are subject to Maldivian, like arbitration clauses are subject to Maldivian law and Maldivian arbitration center. So there is a trend towards that as well. So about drafting robust ADR clauses, I think as a draftsperson, having worked in, for example, tourist resort sale and purchase acquisition ventures, I notice that the most important thing is when drafting ADR clauses is to be very clear and very precise and specific. So example, certain things you have to mention, like what are the rules? How would you resolve a dispute? Like what is the, what would be the venue? What would be the process? Is it going to be mediation? Is it going to be arbitration? Or is it going to be a mix of like a multi-tier dispute resolution clause? If the ADR clauses are not clear, it has been established in the Maldives law context by the Supreme Court. There's this very famous case, one tourist operating company against the Hilton management group that went all the way up to the Supreme Court, in which Supreme Court decided that ADR clauses in an arbitration, for example, in the arbitration context, it said arbitration agreements would be interpreted using the same rules of construction of contract the courts usually employ. So it gives us an indication if an ADR clause is not clear, how would the courts go on about interpreting that clause, at least in the Maldivian context. And one of the cases I would like to really highlight is there was this one case which is also in the tourism sector related tourism context. There's this one case which involved a multi-tier dispute resolution clause. This case went to the civil court. SPH was Jumeirah Management. So SPH is the headless C, and Jumeirah was a management company. And what happened was the management agreement was terminated, and SPH went to the civil court praying that the court determined that the termination was valid, and that once the case has been put forward into litigation, the parties cannot choose any other forms of dispute resolution that they have agreed within the contract. Interestingly, this contract has a multi-tier, like multi-levels. They first agreed to resolve a dispute through the senior officers, and failing which, the parties can either elect an independent expert, or any party can start arbitration or start civil proceedings. And there was this one clause within the dispute resolution clause that stated if parties start litigation, the court of competent jurisdiction will have non-exclusive jurisdiction and the other party cannot choose, for example, independent expert and arbitration proceedings. So what happened in this case was Jumeirah had already gone to arbitration, and that was when SPH filed a case in civil court, and the court had to do an interpretation exercise. And because it was not very clear if a party had come to court, but the arbitration had started before this, what did the parties intend through their dispute resolution clause? The court dismissed the case for different reasons, because under the Arbitration Act, a defendant in their first statement of defense can say the matter is already in arbitration, and so the court has the power to refer the matter to arbitration. On that ground, it was dismissed, but the court did an interpretation exercise saying that if the parties had intended arbitration to be a form of dispute resolution, then if arbitration had already started, that means the court must give effect to that. So that was an interpretation that was drawn by the court. So to summarize, in the Maldivian context, it's very clear if the parties have agreed on ADR, if there's an ADR clause, the courts will give effect to ADR clauses, but also very important to ensure that the ADR clauses are clear. It has it states the rules that applies to dispute resolution, the venue and the process, so that there is no room to contest it and go to court and litigate it out. We know that courts will use their discretion to interpret the clause because it has been the set precedent in the Maldives based on existing limited case law. About strengthening ADR mechanisms, I think one of the ways to ensure that Maldives has an effective ADR mechanism is to ensure that we strengthen and enhance ADR mechanisms. For example, MIAC has made quite significant strides. I've read that they do online case management as well, and I think rules were a bit relaxed during the COVID times. And I'm not sure whether, it's not within their official rules yet, whether they allow virtual hearings, but I think technology can intersect with ADR mechanisms. One other way forward in the Maldives context, as I would see, is it's very important for us to, as a nation, to incorporate the Singapore Convention on Mediation into domestic legal framework. We do have ad hoc mediations that are conducted in the Maldives, but not necessarily those will be coming under the governing law. Like Maldives would be the governing law. So as mentioned by one of the speakers, Maldives is an economy that has sectors, like one of our largest sectors are in foreign investments, at least, is tourism sector and the real estate construction sector. So it's very important that we also open our doors to mediation, also recognize settlement agreements reached through a mediation, so that the parties have efficient enforcement mechanisms, even if a dispute is mediated in the Maldives. So those are my thoughts on the topic, and hope that has been helpful. Thank you.
Thank you, Ms. Shafia. Before I move to the next session, and before obviously the question answer session, I actually do have a question. So do you agree with the interpretation of the courts in the case of SPH versus Jumeirah?
SPH versus Jumeirah civil court decision, I would say, I think it's very hard for me to comment on this because I worked on the expert opinion for the arbitration matter, so I cannot say anything about it.
No, I don't intend to put you on the spot. I'm just, the only reason I wanted your view was that because I was of the view that if parties have entered into litigation, and we all know litigation take minimum 3 to 5 years sometimes, if you're lucky, and arbitration can hopefully be between 6 months to 1 year. So the courts may be more inclined towards ADR mechanisms to maybe lessen their burden. But that's just my view, and I just wanted your view on that. I didn't.
Well, that was the decision, by the civil court. Civil court said, because they have started arbitration and because they've also agreed arbitration as a form of dispute resolution, it is only right the court interprets in a manner that gives effect to that provision as well. It was very unclear because the clause stated that once a party goes into litigation, all other avenues would be precluded. So Jumeirah has gone to arbitration first. So the court was like, okay, you have this clause which precludes arbitration, but now that they have gone to arbitration, you have to also give effect to that clause as well.
That's interesting, yeah. But I guess that's why it's very important to have a precise arbitration or an ADR clause in contracts, so that issues like this don't arise. And with respect to your suggestion about Maldives passing legislation which brings into effect the Singapore Convention, that's also something we in Pakistan also take into account, because we just received the agreement. Not the agreement, sorry, we just received the consent of the government to enter into the Singapore Convention. And because Pakistan also has a dual law, so any international law, for it to have effect in national law, there needs to be a law passed. And I believe Maldives has the same status as well. So that's why a local law would be very helpful to implement any mediation decisions, internationally speaking. And thank you, Ms. Shafia. Thank you so much for the very comprehensive and for the examples as well, for the comprehensive overview of how we can implement such practices in the Maldives contracts. Thank you. We'll now move on to the next speaker. So for the fourth speaker, let me just move this. Yeah. Thank you. Yeah. So the last session of the day shall be presented by our fourth speaker, Dr. Daksha Sharma, who is an assistant professor at the South Asian University. Interesting thing to note is that SAU is a sister body of SARCO. We all come under the head of the SARC, the South Asian Association for Regional Cooperation. Just by a way of brief introduction, Dr. Daksha Sharma is an assistant professor of law at SAU, which is based in New Delhi, and she also serves as an arbitrator at Prasar Bharati. She is also a visiting faculty member at several prestigious institutions, including the Delhi Police Academy and the Indian Law Institute, where she regularly lectures on constitutional law, ADR, international law, and human rights. Dr. Sharma is the founder of Rising Stars, a community service program focused on the right to education for children in New Delhi. She has held key academic and administrative roles at Bennett University and MIT Law School. Dr. Sharma holds a PhD in international law from the Indian Law Institute and has practiced law, contributing extensively to socio-legal seminars and research publications. Dr. Sharma, we are extremely grateful to have you on our panel of speakers. And if I may ask you, given that you have recently conducted a research project for SARCO, what practical advices can you share from the SARC region, which can further strengthen the practices in, say, for example, in Maldives?
All right. To begin with, first of all, I would like to thank Mr. Barrister Mangrio for inviting me at this prestigious platform. I would like to congratulate SARC Arbitration Council for organizing this program on island mediation, tailoring ADR for commercial disputes in Maldives with a focus on tourism and real estate sector. So interestingly, my topic is strengthening ADR practices, insights from the SARC region. And I feel myself to be extremely privileged to be the member of this esteemed panel. And already experts have shared their views about strengthening ADR practices in SARC region with special focus on Maldives. So now I would like to first talk about alternative dispute resolution as to, how the system has grown over a period of time. So when we talk about alternative dispute resolution, essentially the fact is that it is providing a viable solution for peaceful dispute resolution for the litigants. The glaring reality is that courts across South Asia, across globe, are already overburdened with a number of cases. So therefore, there is an imminent necessity and an urgent demand to cater to the needs of the litigants. ADR has become a popular and an accepted form of dispute resolution method, not only in South Asia, but across the globe. And same is reflected through various legislative steps taken by the governments of SARC region. Now, let's talk one by one the cases under SARC region. For instance, if we take into consideration Bhutan, we find that various ADR centers have been established to expedite the justice delivering mechanism in the country. In Maldives, almost 50 to 60% of the cases are getting resolved with the help of ADR mechanism. And as far as the recent deliberation is concerned, we have understood that it is to be synchronized with the Singapore Convention. In Bangladesh also, Section 89A of Civil Procedure Code provides for mediation as a viable option for dispute resolution. If we take the case of Sri Lanka, we have enactments such as Arbitration Act of 1995, Commercial Mediation Center of Sri Lanka Act of 2000, Mediation Special Categories of Disputes Act of 2003, Mediation Civil and Commercial Disputes Bill of 2023. Nepal also has a very long history of ADR, and it has enacted laws to promote and strengthen arbitration. The Arbitration Act of 1999 is the primary legislation governing arbitration in Nepal. Similarly, ADR is a significant part of Pakistan's legal system also, as already been discussed. And therefore, we must consider this fact that it has been incorporated through Section 89A in CPC, and also the efforts are reflected by way of enacting Alternative Dispute Resolution Act 2017 and Punjab Alternative Dispute Resolution Act 2019 as amended in 2023. So it is interesting to note that across SARC, we find that ADR is gaining prominence. If we consider example of India, we find that ADR is used as a tool to resolve disputes peacefully and effectively since time immemorial. If we take the example of panchayat system, in ancient India, disputes were resolved with the help of panchayat system through different panchas. The first formal statute relating to the subject of arbitration in India was enacted in 1940. And if we talk about recent amendments to the Arbitration Act, we consider amendments of 2015, 2019, and 2021. Interestingly, in 2023, in India, Mediation Act was also enacted. Not only this, online dispute resolution is also gaining prominence in India for effective dispute resolution. Now, let's talk about the role of SARC Arbitration Council in peaceful dispute resolution. So when we talk about SARCO, we must understand that since inception, SARCO is playing its role eminently and is instrumental for resolving disputes peacefully. In fact, in the recent past, if we see that various activities have been conducted by SARCO for disseminating knowledge about ADR practices. So this stands testimony to the fact that SARC Arbitration Council is playing an effective role for dispute resolution. Now, I'll come to the last leg of our discussion, which is strengthening ADR practices in SARC region. As far as we focus on the solutions, I find that first of all, the need is to use the technology for the betterment of ADR practices across South Asia. So therefore, the need of the hour is to promote online dispute resolution. harness artificial intelligence and modern technological advancements for making ADR even more effective, progressive, and dynamic. Also, as previously stated and discussed by eminent panelists, that there is a need for clear incorporation of arbitral clauses in the contract. So if we have clear arbitral clauses, then certainly half of the disputes are resolved automatically. Also, there is a need to harmonize the principles of international law in municipal regimes across all the South Asian nations. Further, I believe that scope of ADR will furthermore be enhanced with the usage of modern practices of ADR such as MEDARB, ARMED, MEDOLA, and so on and so forth. So therefore, we need to modernize the concept of ADR itself as and when required. Also, during ADR processes, it is needed that there should be clear reflection of principles of natural justice, which includes transparency, fairness, reasonability, rationality in all the arbitral awards. And there should be reasonable and minimum intervention of the court as and when required. So therefore, if we talk about the concept of judicial review also in arbitration, according to me, it should be minimized as per the need of the hour. Also, we can think of introducing new concepts such as emergency arbitral awards for providing a quick interim relief to the parties to the disputes. Also, we can think of creating e-depository of arbitral awards, which states that, the entire arbitral process should be digitized, and whenever required, such awards can be accessed. As far as alternative dispute resolution is concerned, cost and time factors are extremely important. So therefore, we should make efforts to make such processes cost and time effective. So therefore, to conclude, I would like to state that we have progressed a lot as far as ADR practice is concerned across South Asia. And further, the system will be more in demand in the coming times. And therefore, we also need to equip ourselves with the modern technologies so that we can make this entire system effective, dynamic, and also catering to the needs of the litigants, who are the real beneficiaries of the entire process. With this, I would like to thank each one of you for your participation. I'm also thankful to the esteemed panelists who shared their vision about ADR practices. I'm really thankful to SARC Arbitration Council for inviting me to this prestigious platform. It really gave me an opportunity to understand the system in a very deeper way. I thank you one and all. Thank you. Have a good evening.
Thank you, Dr. Sharma, and always a pleasure to have you with us on our panels. And a number of key points that you raised are concrete suggestions. I completely agree with them, especially the part about the emergency interim relief. As the panelists and the audience members may know or may not know, we've had our rules, the arbitration mediation rules, based on 2015, which were then based on the UNCITRAL rules of that time. We have recently made some efforts to update our rules, both arbitration and mediation. And in some places where it's necessary, we have put in the technological use of platforms for ADR processes. And in some places, we also put in interim relief, in which emergency interim relief, in which an practitioner or an arbitrator could be appointed within 24 hours notice, and who could maybe pass an emergency order, which then protects the rights of the relevant person. So with that, thank you, everyone. We have reached the end. Now, before we move to the closing session, we'll just take a brief 5-minute time to see if there are any questions from the audience members. So if there are any questions, you may please raise it in the comments, the chat section, and then we can maybe ask the relevant speaker on that. So we have two questions for now. One is what future innovations or policies could strengthen ADR in Maldives? Ms. Shafia, if I could ask you maybe to respond to this.
Sorry, what future innovations or policies could strengthen ADR in Maldives? I think we need. Already I think the government is working on amending the Arbitration Act in order to include the mediation component, and also some of the changes that they have seen over time that requires to be put in the legislation. But I think we need to embrace technology, especially post-COVID. We have had a lot of strides in this area. For example, courts have gone online, which is a big thing in the Maldives context because we are all dispersed across the islands. But in the commercial context, technology would help us conduct and facilitate cross-border disputes involving Maldivian properties with multiple parties based in different jurisdictions. And also exchange of knowledge and transfer of skills, because or in these kind of transactions or in these kind of matters, we work with many foreign law firms and legal teams and experts. So I think definitely there is scope for us to intersect with technology. I would say that is something we should adopt. Also, not only think about large scale commercial transactions, but in small civil commercial transactions as well. If we can get mediation, and if we can get it through online case management systems or online platforms, that would relieve the parties from going to the court where the cases stay in the court system for 8 to 12 months without proper relief at best. And this has also reduced the costs of them seeking this form of dispute resolution mechanism instead of going to litigation or arbitration. I think we should try to facilitate mediation more in the Maldives as well. And train our people, have policies to foster Maldivian lawyers and technical professionals to have to be trained in mediation. For example, construction industry is a big industry in the Maldives. We can have surveyors, quantity surveyors, or technical people within the industry to be trained. So we need some positive policies in the Maldives that can help and support the sectors when in the event of disputes. And I think mediation has a greater role to play. The way the Maldives is and the kind of money the parties can afford to spend on resolving their disputes, I think mediation is a very good alternative in the Maldivian context.
Thank you, Ms. Shafia. For the second question, I think this is aimed towards me, Dr. Raksha Sharma. What initiatives can you propose for ADR development in Maldives? I think maybe building on the same previous question, what kind of steps, Dr. Sharma, do you foresee maybe you could implement in Maldives to make it even more better?
So I would like to second what honorable panelist Ms. Riza has already pointed out, that there is a need to embrace technology in ADR practice in Maldives especially, and also there is a requirement for dissemination of knowledge related to ADR. Now, as we understand that traditional court system is already overburdened, so the need of the hour is that we should equip ourselves with the processes which help us in dispute resolution in quick way. So therefore, Maldivian system is no exception in this. So therefore, the the necessity is to have the processes which actually facilitate dispute resolution in an effective, progressive, and dynamic way. Also, we can think of introducing new techniques, as already pointed out, like Medola, ArbMed, MedArb, and also a system of Lok Adalats, People's Court, so that, small disputes of civil nature, of family nature can be resolved quickly with the help of such systems. So therefore, the thrust is that ADR should become a tool to resolve the disputes in a cost and time effective manner. So if this is happening, we are successful. So therefore, every possible effort should be directed in this aspect, that dispute should be resolved peacefully, and also keeping in mind cost and time factors. So, this is my viewpoint. Thank you.
Mr. Moaz, we'd love to have you as well.
Thank you so much again. Always wonderful to join these sessions, and with His Excellency as well. Saqib, thank you for again bringing in Maldives into the discussion. When I was doing just the last time, I think it was last year, where you hosted, and then we one of our panelists actually, if you remember, he also passed away. But I remember there was a discussion on mediation, and how mediation was very central to Singapore, the Singapore Convention, and Maldives being one of the first countries. In fact, I think it's country number 2 or 3 to ratify it. And what I thought was also interesting as to why that was the case, and I'm not too sure if most people know, but the commercial courts in the Maldives, there was a statistic I was reading for about 5-6 years data since 2015 to 2021. There was about 22,000 estimate civil court cases and filings, of which about 17,000 were referred to mediation. So, and then from that, almost 62% were successfully mediated. So this goes to show that there's a lot to learn from Maldives, and would like to learn more about this mediation success, which is part of the ADR spectrum as well. And I think also important for the region, as this is the next upcoming, because of the Singapore Convention, as you mentioned as well. Pakistan has also kind of somewhat assented to eventually signing it, and then domestic legislation, as you mentioned. But I think learning from these success stories from each other, we can get some more viable information. There's a lot to learn from Maldives, and I wish if there was a lawyer, perhaps Madam Shafia would like to comment a little bit more about the success of mediation before even signing on to the convention, and what we can learn from the Maldives framework when it comes to commercial disputes and mediation as a solution. Thank you.
You are right. Actually, when we had the court-led mediation, we call it dispute resolution section within the civil court, the statistics show that roughly around 60% of cases got resolved through the dispute resolution section, and then the remaining only went to trial stages. So that was indeed very effective in the Maldivian context. That is even before 2019. That is when we signed the Singapore Convention. But I'm also a pro new civil procedure code person. With the new civil procedure code, we have had the procedures detailed, laid out. It's more systemic, it's more open, it's more transparent. Right now, the Civil Procedure Code also shows a pathway to achieve a similar result, where parties can opt to go for an in-court-led mediation or an out-of-court mediation. The court has not, as far as I'm aware, has not established this mechanism within the court system yet, and there are talks that and in fact, there is an amendment to bring back the old dispute resolution, division to the civil court, which also it has its pros and cons. What as a lawyer, as a practitioner, I like the fact that there is transparency, there is certainty, and how much of clarity the civil procedure court is bringing. And I can also see how a private mediation practice can be thriving when we have the civil procedures, out of court mediation system in place in the Maldives as well. But the systemic framework is not there yet. And therefore, there is also a significant thought to bring back the old dispute resolution mechanism. So I think we'll have to find a balance.
No, thank you. That was very meaningful.
Thank you, Ms. Shafia. I think that answers the question in the chat as well. So I think now we can move towards the closing session. So ladies and gentlemen, thank you very much. I extend my heartfelt gratitude to all our esteemed participants, speakers, and partners who have contributed immensely to the success of this event. It has been inspiring to see the level of engagement from everyone, and I believe that the ideas we explored today will play a crucial role in shaping the future of ADR in Maldives. I would just like to add that I'm happy to see that SARCO, RCO lawyers, the Maldives Moot Court Society, Harmony Resolution Center, and SAU working together on such important initiatives. And I hope that we can work in the future as well. As I conclude today's event, I encourage all of you to continue the conversations that we've started today. At SARCO, we remain committed to advancing the scope of ADR, whether through training, research, or facilitating cross-border collaborations. We are here to assist in any way we can. Together, we can make the vision of a strong and effective ADR system in Maldives a reality. Before I say the thank yous and the goodbyes, Madam Shafia, would you like to say anything in the closing?
Thank you. Firstly, I would like to give my thanks to SARC Arbitration Council for giving us this opportunity. I think it's very important dialogue to have, and I hope the next time around we can have more local participants as well, so we can internally take this conversation forward with the relevant partners, obviously being present. I think Maldives is, as Dr. Daksha mentioned, we are in dire need of enhancing our skill set, especially knowledge in terms of ADR. And I think there is a lot of work that can be done within the Maldives to promote ADR mechanisms, especially in terms of people and capacity building. And I hope we get to have more conversations like this and exchange, knowledge and information with our colleagues across SARC. Thank you.
Thank you, Ms. Shafia. And just building on that, I would just like to say that hopefully we will be coming to Maldives in 2025. Because we had a virtual event this year, we are planning on having a physical event next year, hopefully.
That's great.
And we will hopefully be very excited to work with you. So thank you, ladies and gentlemen. We will now be concluding a webinar. Thank you for joining, and I wish you all happy holidays.
Thank you.
Thank you, everyone.